A warm welcome and good morning and good afternoon to those joining. We are very happy to see so many people joining. We'll just wait another minute or so and then we'll start the official part. Thank you so much for joining. Thank you so much for sharing the slides. A warm welcome to those who've joined us. A good morning or good afternoon, good evening, depending on where you are joining us from this morning to this virtual briefing on the civil society engagement mobilization for the International Court of Justice Advisory Opinion, which is a campaign that has been running for several years, but we're at an incredibly crucial time with the deadline for states to submit coming up on the 22nd of March. So that's exactly 4 weeks from now. We are so grateful that so many of you have joined us today to learn a bit more about where we are in the process, where it came from, what the goals are, and of course, what we can all collectively do in these last 4 very important weeks. My name is Jule Schnakenberg. I'm with the World's Youth for Climate Justice, one of the youth organizations that have been kind of lobbying for this for several years. I'm based in The Hague, and I'll be moderating the session, but this is really all about our guests, and we have some wonderful people who are able to join us online live, and then some people who had to share video statements because they're unfortunately not able to join us at this time. But yeah, first, maybe a huge thank you to the Center for International Environmental Law, who's doing all the tech support and the chat support. There's a chat function at the bottom, and there's a Q&A function. So any questions that come up for you during the next hour, please feel free to insert it in there. There's a little Q&A button, and there's a chat function as well, where Francesca will be sharing links and other information that might be relevant that speakers will mention. We have a second session at 4 p.m. CET, so that's for to include the Americas, and there'll be interpretation in Spanish. So if you'd like to hear everything again with a slightly different twist and Spanish interpretation, you are welcome to join us later today as well. This webinar is co-sponsored by several organizations, and a big thanks to them as well. Pacific Island Students Fighting Climate Change, the Inter-American Association for Environmental Defenders, in short, AIDA, which many of you will be familiar with, Natural Justice, the Environmental Lawyers Collective for Africa, the Center for International Environmental Law, and the Climate Action Network. A big thanks to everyone who supported in the process. And I think that's it for housekeeping matters. And then I think we can jump right in. And as many of you will have heard, this is an initiative, I mean, for many years, lawyers, diplomats have been thinking about it, but this very successful push, the very successful initiative was started by young people in the Pacific, and we're very happy that Vishal Prasad, the campaign director for the Pacific Island Students Fighting Climate Change, was able to share a video statement with you, and he's been able to record something in advance. He's based in Fiji and unable to join, but Camilla, I think we are good to hear his statement on the rationale and the goals of this campaign. Unfortunately,
Ladies and gentlemen, it is so great to see this briefing come together to update all interested partners and supporters on where the ICJ AO campaign is and the areas in which we will need your support in. I will begin by briefly highlighting this campaign's origins and rationale and help set the scene for our discussions today. We launched the campaign to seek an advisory opinion from the International Court of Justice to request the court to clarify what states' obligations are in protecting the rights of current and future generations from the adverse effects of climate change. As many of you would know, this campaign began in the classrooms of our regional university by 27 law students determined to contribute a meaningful solution in the fight against the climate crisis, against the backdrop of a global impasse in climate action. We see that the advisory opinion could act as a legal circuit breaker to the political impasse on climate change and will help to catalyze greater climate action by integrating climate law and human rights law, promoting more ambitious action under the Paris Agreement, cementing consensus on the scientific evidence behind climate change, and by providing authoritative baselines for country actions and for adjudications at the national, regional, and international levels. For young people, this campaign is a declaration that we do not wish to stand on the sidelines as the climate crisis ravages our homes and our planet. While it has been progressing, global action on climate change is not moving at a pace that would avert catastrophic danger, and there is a need for an all-hands-on-deck approach to addressing the climate crisis. The recent IPCC report confirms this prediction of an even bleaker future if we do not change course. We do not accept this fate. We choose to retain hope that our countries are resilient and that international law and its institutions remain a global beacon of respect for a just and peaceful international order that can illuminate the path ahead for us. This is why we take on this fight for climate justice and why we intend to seek an advisory opinion from the ICJ. Since the beginning, we have campaigned for an ICJ AO that focuses on human rights and intergenerational equity. And we're delighted to see that the current legal question before the ICJ has a strong focus on this. Why a human rights question? Because human rights obligations provide a legal basis to compel stronger and more rapid action by governments. They highlight the moral high ground we stand on. It is a forward-looking approach that focuses on the future and avoids naming and shaming and is therefore more likely to gather support. And human rights have more radical potential due to being inalienable and not based on the lowest common denominator or political convenience. Negotiations under the UNFCCC framework remain one of the most important tools in addressing the crisis. An advisory opinion can promote more ambitious action under the Paris Agreement. The voluntary nature of the Paris Agreement requires continued encouragement for more ambitious action among states, and the advisory opinion, while complementing the Paris Agreement, can also encourage greater action. In doing so, the advisory opinion would also help set more concrete and authoritative baselines for state action in reducing emissions and meeting their human rights and climate action responsibilities fully. In this way, an ICJ AO would not be an attempt to undermine, but rather complement and bolster global climate negotiations. More broadly, the ICJ advisory opinion would provide and empower civil society organizations and climate activists with a potent tool to combat environmental injustices worldwide. Having the security of a clarified legal position would mean new and stronger forms of action that activists can lead, resulting in protecting the environment and pollution control becoming serious considerations and action points for states. Not only would the ICJ AO be a legal circuit breaker for global negotiations, it would also be a major confidence booster to the work of all climate activists worldwide. Our journey towards climate justice now needs the support of countries to advance strong, robust, and ambitious submissions before the ICJ so that the final opinion is informed by this. There will be several lukewarm, much business as usual submissions before the ICJ, and we need to rise above these and seize this opportunity to shape the development of international law to work for our people. This is a generational opportunity, and we need countries to stand on the right side of history and make the most of this opportunity on the 22nd of March so that the next time when we go to a COP meeting or a negotiation meeting, we will be going from a position of strength. The ICJ advisory opinion can help make that happen. Vinaka Vakalevu, and thank you.
Thank you very much for the video statement, Vishal Prasad. He's the campaign director for the Pacific Island Students Fighting Climate Change. So the group of students that had, back in 2019, started the very public campaign that reached out first to other civil society organizations across the Pacific, really involving communities, and then later building a global alliance. But this very special and important case that Vishal was just speaking about was only made possible because of this very strong alliance that started in the Pacific involving children, youth, women, indigenous peoples. And one of the organizations that was involved from the very beginning was Greenpeace, Australia Pacific. And we have the great privilege that Shiva was able to record a video statement for you this morning, who is the Pacific Community Engagement Manager for Greenpeace Australia Pacific, speaking to us also on the specific importance of the advisory opinion for Pacific governments and CSOs. So Camilla, over to the video, please. Thank you. Thank you very much for your patience. We will keep working this. Camilla, shall we move ahead and come back to this? What would you prefer?
Just give me a second and we should be ready to go.
Good. In the meantime, may I say that if you do have a question, please feel free to add that to the Q&A. There's a function at the very bottom for that. Feel free to introduce yourself when asking a question. That helps us to know who's in the room, and hopefully answer your question in a way that's more relevant to you and your specific circumstance or consideration needs. Thank you so much.
Hello, Vinaka. My name is Shiva, and I'm the head of Pacific of Greenpeace Australia Pacific. And I just want to say a big Vinaka Vakalevu, a big shout out to PCAN for providing me this opportunity, I guess, to share a little bit of the importance of civil society organizations and governments working together in this process and moving forward. You know, this campaign in itself is a incredibly beautiful case study and successful case study of what is achievable when civil society organizations and governments work together with love, with trust, with passion and drive, with the support of resources, etc. And you know, a campaign that started in few classrooms in the Pacific Islands with the Pacific Island students fighting climate change, championing this, and then taking this ambitious campaign and sharing it with the Pacific leaders, and then Vanuatu jumping on and saying that they will champion this effort with the Pacific Island students and resourcing it, creating spaces of lobbying, working together to shape strategy and all those things. That is the main reason where the campaign got to and where it is at right now. You had civil society organizations doing, I guess, their own things, and the government's doing their own things in terms of lobbying, in terms of actions, in terms of mobilizing, in terms of events and side events, but there was this common underlying thread of why we were trying to do the work we were trying to do, and we would get together to collaborate regularly and discuss the steps moving forward. And there is a role, I guess, and then you heard the result that happened in March, the historical announcement in March last year, when the resolution was passed through the UNGA without a vote being needed, rather by consensus, and that's the first time in history to the International Court of Justice. That's the power of civil society organizations and governments working together. And there's a step, like I said, there is a role for civil society organizations in the second phase of this campaign, which is the submissions process. Governments can't make it the most powerful submissions by themselves. Civil society organizations has an advantage compared to many other groups and also governments. We understand the cultural pulse of our communities. We have experienced and seen the impacts of climate change in terms of all areas of human rights within our communities, how it impacts First Nations groups, how it impacts women, how it impacts children, youth, etc., in terms of livelihoods, in terms of food insecurity, or food security. All of these things, the civil society organizations understand the cultural pulse of this. So the civil society has a role to play, I guess, to make it the most powerful submissions, or help the states to make the most powerful submissions. A case study is that you've got Pacific Island Students Fighting Climate Change and Greenpeace. We've been currently working to try, and in the last year, we've been working together as much testimonies and case studies and I guess evidence from local community on how climate change has impacted their human rights in all areas. And then we are sharing it with states and intergovernmental organizations to see if they can put it as part of their submissions, either in their submission or as part of the annex of the submission, because what our communities face, the true impacts, the realities on the ground, needs to be reflected in our submissions, because that is what will make it the most powerful. So I guess a thought for anyone listening is reach out to your government, reach out to the legal teams that are trying to help your government, and see if they require any assistance in gathering testimonies, case studies on the ground, and see if they would be open to you to gather those evidence, get the right consent, etc., and then share it with the team, and hopefully they can make it as part of their state submissions. I feel like that would be a great opportunity for how civil society organizations can be part of this process. And there's one more way, is that there's very little time now, and countries, if they don't make a submission, they won't have an opportunity to be part of this process, or as I understand it. So even a two-page submission, one or two-page submission that could get their feet into this submission process, allows them to be part of this whole 1 year journey that we'll be going through. So try and pressure your governments to make a submission, even if it's a short submission, make a submission, because it will help them to be part of the process moving forward. So that's all. For your time, and thank you again. For listening to me. Mother.
A big thank you also to Shiva, who's been involved with the campaign for several years, doing some incredible work across Pacific Islands, gathering that those testimonies that he just mentioned to be included in state submissions. And thank you for raising the importance of working with states and civil society together and supporting states in the work that they are doing, or that we hope that they are doing. And some of our speakers today will also speak on that a bit more. But before we can turn to those who are able to join us in person, we have a final short greeting message from the UN Special Rapporteur on Human Rights and the Environment, David Boyd, who is going to. Vishal briefly mentioned why it's so important that the question is a human rights focused question, and he will also, in his short video statement, speak on the importance of this advisory opinion to uphold human rights of present and future generations, which is something that all civil society organizations have very heavily stressed. So Camilla, over to our final video. Thank you.
Hello from Canada. I'm Dr. David Boyd, the United Nations Special Rapporteur on Human Rights and the Environment. We have a once-in-a-lifetime opportunity to clarify states' obligations in respect to the climate emergency, drawing upon international environmental law and international human rights law to craft a science and human rights-based approach. But first, I'd like to just quickly acknowledge the leadership of the World Youth for Climate Justice and Vanuatu, with the support of 18 other states, as well as other civil society partners, in successfully securing a General Assembly resolution requesting an advisory opinion on state obligations in the context of the climate crisis from the world's highest court, the International Court of Justice. The climate crisis is unequivocally a human rights crisis. Small island developing states, least developed countries, and people in states all across the world who are least responsible for the climate crisis are bearing the heaviest impacts of this crisis. I'm talking about indigenous peoples, people living in poverty, children, older persons, migrants, refugees, and others who find themselves in situations of vulnerability and marginalization. This is a human rights crisis that I have witnessed firsthand in my work as Special Rapporteur. On my first country mission, I went to Fiji, where I visited Vunidogoloa, one of the first communities in the world that had to be completely relocated because of the climate crisis. This oceanfront, beautiful community had to move inland. And so now older persons, persons with disabilities, pregnant women are cut off from the ocean that is their grocery store and the heart of their culture. On my second country mission, I went to Norway. I traveled north of the Arctic Circle to spend time with the indigenous Sami people, for whom reindeer herding is the heart, the beating heart of their culture and their economy. And yet the climate crisis is inflicting incredible problems on reindeer and, by extension, the Sami people. My third country mission was to St. Vincent and the Grenadines, a beautiful island state in the Caribbean. Again, rising sea levels, increasing heat. I spoke to farmers there who said that the heat is just becoming intolerable for working during the day. Then I went to Portugal and spoke to survivors of absolutely terrifying and deadly wildfires made much worse and much more common by the climate crisis. I spoke to pastoralists in Kenya whose livestock, their lifetime savings have been killed by drought. I went to Chile, and Chile is a nation that's in the midst of a multi-decade drought exacerbated by the climate crisis. Most recently, I was in Botswana, where I visited indigenous communities and rural communities that are facing incredible water scarcity, food insecurity, and increasing human-wildlife conflict, all linked to the global climate crisis. In April, I will travel to the Maldives, one of the world's 5 atoll nations. These are nations where the highest point of land is no more than 8 or 10 feet above sea level. So this climate crisis is an existential crisis for the people and the nations, such as the Maldives, Kiribati, the Marshall Islands, Tuvalu, and Vanuatu. We have to address this. And unfortunately, the International Court of Justice rejected a request from a group of special rapporteurs to make written submissions on rights-based approaches to the climate crisis because we don't qualify as an international organization. So it's absolutely critical that as many of the states that are being adversely affected by the climate emergency participate in the International Court of Justice advisory opinion process. The deadline is coming up fast for written submissions. It's March the 22nd, but there are many resources available. There are also academic experts, pro bono lawyers, special rapporteurs, and civil society organizations willing to assist in this critically important endeavor. As I said at the outset, this is a once-in-a-lifetime opportunity to have the world's highest court clarify that states must take a human rights-based approach to all climate action, and that this is an obligation for states, not an option. Thank you very much. And I hope to work with many of you in the future.
Thank you very much for sharing the video, and big thank you as well to the UN Special Rapporteur for Human Rights and the Environment for really stressing the importance of the case and the huge need that there is for states to engage. And we've heard this morning or this afternoon for you, that this initiative came from the Pacific and then spread across the world, and the importance of not just having Pacific states submit, which is hugely important, but also states from around the world, and especially climate vulnerable states, states from Latin America, from the African continent, from the Asian continent. And we're very, very excited to have Noma with us this morning, who's a coordinator for the Environmental Lawyers Collective for Africa, Natural Justice, who is able to share some reflections with us on the engagement of African countries specifically and the opportunities for civil society organizations in this process. Over to you, Noma. Thank you so much for joining us.
Thank you so much. Good morning, everyone, and thank you for giving me this opportunity to basically discuss with you some key reflections, as Jule mentioned, regarding sort of the engagement of African states in this ICJ process, as well as the pivotal role that hopefully civil society organizations specifically can play in this crucial matter. I think it's important for me to sort of start off by discussing a little bit about the historical relationship between the court itself and some of our African states. So the formation of the court was meant to really be a beacon of hope for justice and fairness in international disputes. But the participation of African states over the years with respect to the court proceedings has really been relatively limited. And there are obviously a number of issues and different factors that color the status quo. And some of them obviously involve a lack of financial resources or general awareness about what the court proceedings are like. But others are linked to a sense of distrust of international institutions among some African leaders, especially when you think about the cousin to the ICJ being the ICC. Whilst this is the case, though, there's really been the ICJ, I think, has really been a crucial institution in resolving disputes between states and providing advisory opinions on legal issues that basically influence international law generally. From an African context, the court has been engaged in questions of land boundaries or armed conflicts between African states. What comes to mind is some matters that the court handled between the Congo and Uganda, Kenya and Somalia is another one, and there are a whole host of other different matters that it's dealt with. I think I shared a link to ICJ case list website with the moderator for you to have a look at if you want to delve into those substantive matters. But despite these challenges, I think the court has increasingly become a forum for African states. So not only issues that are pertinent to African geopolitical instability, and climate change and the climate change crisis basically is a huge example of that global issue. As we all know, Africa suffers more climatic shocks than any other jurisdiction. And yet it contributes the least to climate change. And it's that specific disparity that underscores the urgency for African states to engage with the advisory opinion process and to seek legal remedies to address the devastating impacts that the crisis might have on the continent's populations. So basically in January, what ALCA did, based on basically the inspiration that we drew from the Vanuatu people and the work that WUI for climate change basically had done, what we did is we partnered up with a number of key organizations and partners across Africa and globally. And we put together a draft letter that could be used by any civil society organization or any lawyer in different African jurisdictions to take their governments to task about the participation in the advisory process itself, and to request them to basically include really strong propositions for the protection of the environment in the manner that basically benefits future generations, and for the inclusion of opinions of affected and vulnerable communities in their submissions as well. The letter tackles other obviously pertinent issues, things like loss and damage, mitigation and adaptation, And so far, we've reached out to about 15 or so African countries, including Uganda, Zimbabwe, Nigeria, South Africa. And of this big number, only 2 countries have highlighted their intention to make submissions, whether directly through us or through other stakeholders who we've been aligned with and partnered with. And these countries are basically South Africa and Mozambique. So it's ALCO's hope really that we can continue to encourage state participation in this process, but we've encountered several challenges when engaging with these states. There's a general lack of political will. Some of them tend to use excuses like they've got limited capacity or limited resources to participate in the submission. And what we've done is to suggest basically for us to be given an opportunity to draft something together and hand that over to different ministries that they can then assess and augment, bearing in mind the fact that Africa has 54 countries and is, as I mentioned, extremely vulnerable to climate change. And so our hope today is really to galvanize civil society organizations to work with us, to place pressure on our governments, and to get them to recognize the fact that they have a duty and a responsibility to participate in this crucial process, in this international dialogue on climate justice. I've sent through links to the draft letter and the annexure, which can be amended and adapted by anyone. Please have a look at it and send it off to your local councillors, your state ministries, your head of state even. I think we as a campaign, we definitely firmly believe that civil society organizations can play a crucial role in assisting and participating in this process, whether that's through raising awareness about the ICJ itself or basically monitoring the progress of some of our states and holding our African states in particular accountable. So to close, really, I know that the advisory opinions don't necessarily have binding authority, but they really do go a long way in creating a persuasive authority about the content of international law. And the engagement with African states is very crucial if we're going to reach or realize our goal of building a more healthy, sustainable living environment for our future generations. So I'm calling on all civil society stakeholders to take up the mantle that has been so strongly held by the Vanuatu people and help us in this campaign to galvanize a lot more state engagement and action. Thank you so much.
Thank you very much, Noma, for those reflections on the engagement with different African states, and especially your call for civil society actors to be involved and engaged, and hopefully mobilize more state participation and progressive state participation. Thank you very much. And I see that there's some questions, so I invite the panelists also to have a look at those already if there's any you think you prefer to answer in writing. Otherwise, we do have time for Q&A after, so our audience members are encouraged to add their questions to the Q&A, and feel free to also use the chat to introduce yourself, and we can hopefully build some helpful synergies and connections between those attending this webinar on civil society engagement on these during these last 4 weeks. And finally, Joie, last but not least, Joie is an attorney with the Center for International Environmental Law, one of the co-sponsoring organizations for today, and a senior attorney. And Joie, I'd like to summarize. So now at different kind of points in time, we've spoken about where we are right now in the submission process. And I'd like to ask you if you could share with us what you think the state of play of this process is, and considering we have 4 weeks, what are short-term opportunities for engagement with states as civil society actors? Thank you, Joie.
Sure, thank you. So zooming out, as Jule said, there are 3 different advisory opinion processes ongoing now before the International Tribunal for the Law of the Sea, the Inter-American Court of Human Rights, and the International Court of Justice. And as mentioned today, these together represent a once-in-a-generation opportunity for international judicial bodies to clarify the obligations of states under international law with respect to climate change. At a time of pervasive climate devastation, and when climate negotiations are not delivering at the scale and speed at which we need, this is particularly important. The advisory opinions together could make clear that under international law, states must take all appropriate actions to urgently phase out fossil fuels, align climate mitigation ambition with science, adopt effective adaptation measures, and provide remedy and reparations for impacted communities, and that governments cannot hide behind the deficiencies of the Paris Agreement. But today we'll focus more on the ICJ, but all of these three advisory opinions should be considered together. The state of play in the ICJ process, so around 50 countries have confirmed so far that they will be making submissions, and this number continues to grow. Several international organizations, but mostly intergovernmental international organizations, have been granted leave to intervene, including, and just for example, the Commission of Small Island States on Climate Change and International Law, IUCN, the International Union for Conservation of Nature, which is not purely intergovernmental, has also been granted leave. Interestingly, also the Organization of the Petroleum Exporting Countries, it is important to pay attention to this. Across the world, climate justice-focused countries and organizations are engaging and mobilizing, but so is the other side. Civil society, as we've heard, has mobilized with incredible results and are also planning submissions. Non-governmental organization submissions are not formally on the record as per the procedural rules, but can still be made to the court and can be consulted by judges and states. I saw there were a few questions on this. I'm happy also to answer the questions when we come to the Q&A section. The dates have been mentioned. The dates are really important if you are engaging with your government. So the initial written deadline, the deadline for written input to the ICJ is fast approaching. It is the 22nd of March. Then there's going to be a second round where states can comment on each other's submissions. And that is a critical round because then we will see arguments coming from states we know will raise problematic arguments. So this deadline for written comments is on the 24th of June. Other states, like I think Shiva mentioned this, and it's really important to emphasize, only states and organizations which have filed a written statement by the first deadline can submit written comments in the second stage. So it is critical to encourage your government, or if you're an IO, to get a submission in by the 22nd of March, however short, to reserve the right to engage in the second stage of the written proceedings. We're expecting public hearings towards the end of this year or early next year. Importantly, states which have not taken part in the written proceedings may take part in the oral proceedings. The time allocated for each oral intervention will likely be short, given the expected number of submissions. Two last things to note in the state of play. We have heard from judges at the ICJ that they're interested in hearing as feasible from directly affected communities. It makes a significant difference when judges hear from perspectives rooted in lived experience. States can incorporate or append community testimony to their written submissions or include community representatives in their oral interventions, and it is good to encourage them to do so. This process is about black letter law, yes. It is also about people's lives and livelihoods, about rights and justice. Also, as mentioned by previous speakers, it is important to emphasize that if states are engaging and need resources, these exist. There's a whole ecosystem of support that exists. There is concrete support from the Vanuatu team that has been incredible. There are pro bono law firms, academics, civil society lawyers that have been supporting states with submissions. There are regional rights shops being organized for states, so that support exists. So what can you do in the short term? Reach out to your state. I think many of the speakers emphasize this, especially in the global south, and using this as shorthand. If they're not already planning a submission, encourage them to do so. World's Youth for Climate Justice, I'm sure Jule will drop the contact information, has outreach materials ready and would be willing to share templates. If you work with communities, and there would be a possibility to send community testimony to your state to incorporate in their written and oral materials, this could be an avenue to explore with your relevant state officials. Then very quickly to wrap up, narrative building and mobilization. Keep in mind that law and cases have challenges. They're often not very well adhered to. It is important that the proceedings allow for strategic mobilization towards shaping the narrative around climate change and building political power and the foundational basis for campaigns to advance much needed systemic change. The opinion will be really important, but it will mean little if confined just to the courtroom. Some of these key issues have unprecedented attention now from legal teams of states. We know the media is watching climate litigation. Now, as a broader movement, it is time to raise the volume level of these critical issues of climate justice and the existential stakes. Follow the proceedings, join mobilization efforts that are being planned by campaigners across spaces, from the Pacific Island Students for Climate Change, World Youth for Climate Justice, for example, and continue to push the key climate justice messages that are being raised in climate submissions in public-facing narratives. And then the last point I'll say is non-legal organizations really have a key role to play in the here and now. The mobilization of Pacific youth and all of the others rallying behind them has delivered an amazing breakthrough. But we know that the opposition is mobilizing and could really undermine the process. So we need the constructive voices to come out loud and clear. It'll be important for the court to feel that people across the world are watching and expecting the court to deliver a judgment that not just focuses on black letter law, but uplifts rights and justice. So I'll stop here, and I'm happy to answer any procedural questions in the Q&A session.
Thank you so much, Joy. And I really do love seeing lawyers so passionate and going beyond just kind of written law. And thank you, Noma and Joy, for doing that. So yeah, passionately this morning. There are a few questions in the Q&A, and I'll again draw attention to the Q&A function at the bottom of your Zoom screen. Please do leave questions for our panelists if you have any. And Noma, if it's okay, there's two questions relating to the African Union, and if you have engaged with them over the past few months, I think it'd be interesting if you could take that question. There was one question from Richard Harvey who had asked about engagement with the African Union team, who did a terrific job at ITLA, so the International Tribunal for the Law of the Sea. And now I've lost the other question. There's one on the African Committee of Experts on the Rights and Welfare of the Child. If you have engaged with them, if you're able to speak on that. Thank you.
No, definitely. Thank you so much for both those questions. I think I answered one of them in the chat. So incidentally, the African Union itself also has an advisory opinion process where it welcomes sort of organizations and states as well to table to that specific organ or institution advisory opinions on a number of different matters. Climate matters included. At this point, we haven't necessarily engaged with the African Union. Our strategy has been definitely to sort of galvanize and cultivate bilateral engagements between civil society and states. So different state-to-state bilateral engagements. But I think you make good points about maybe sort of tackling that issue at a more international level or regional level and seeing if that has a bigger pull and impact. At the AU summit recently in Ethiopia in Addis, what a couple of civil society organizations did was to hand over a specific declaration. And in that declaration, it did make mention of the ICJ process and the AU being sort of a crucial organ that needs to participate and contribute to the process. There were a number of other issues as well mixed into there, things like democracy, rule of law, food sovereignty. So that sort of sentiment was sort of washed away, quelled away by a number of other sort of more, what people would say would be more pressing concerns. Yeah, I didn't get the second question. The second question was on whether we have engaged the, just repeat the second one, the second aspect for me, please.
Yeah, I'll read that. Are there any efforts to engage with the African Union on this issue and specific organs of the Union with mandate on human rights, including the African Committee of Experts on the Rights and Welfare of the Child, who's been working on children's rights and climate change?
Yeah, yes, we like I mentioned before, we haven't really engaged the AU or any other regional bodies per se, but that's a strong statement that I think we need to sort of consider altering our strategy. What we try and do as well is sort of the AU, coincidentally, last year, October sometime, basically published a commentary on the current impacts of climate change on human and people's rights in Africa. specifically, and it would be nice to see some of the arguments that it made in that specific body of work being inculcated into any type of submission that the AU would make. So that's something that we might be able, as civil society, to basically drive this organization to be able to do, because a lot of the arguments that were put into that report were actually very much proponents of protecting the environment, protecting our people, and not continuing to expand this growing expansion of fossil fuels and gas on our continent. So it would be good to see those arguments make their way into any type of AU submission, even though a number of AU member states currently are proponents of the right to develop, which involves exploration of gas, exploration of fossil fuels. So there's a lot of inconsistency when it comes to its policies and its statements at times on this issue.
Thank you very much for the response. Joy, if you're okay, we'll yeah, there's lots of questions, so I'll just put that back to you, Joy. Someone had asked if an NGO is wishing to submit a statement, and you briefly mentioned that as well. Given they aren't officially allowed to, because this is a process that where only states are allowed to make submissions, and then those international organizations that have been granted leave to submit, are you able to speak on procedurally? What does that mean? I print one copy, I walk to the Peace Palace. The person asked about 30 copies. Are you able to speak on the procedural aspect a little bit? Thank you. You're still muted, Joy, sorry.
Sorry. So the process is, as far as we understand it, and while they say that there is this right to send in submissions, they don't really talk about how it's different from states. From what we have heard, and we are still confirming this with the registry, is that sending in one email to the registry at the email that is there in the rules of procedure, and one hard copy to be placed in the should be sufficient. But we are still confirming this information with the court. The deadline, again, is also not necessarily clear from the rules of procedure if non-governmental organizations need to meet that same deadline that is there for states and IOs that have been granted leave. But as all of the CSOs that I'm aware of that are engaging are really taking this as the deadline to submit. So I think, let me see, is this? Yeah, so that's the information I have right now, Ryan. And if we hear back from the registry when we follow up after this webinar, I'm happy to include any updated information. And with Laura, would it be possible to share some of the contacts of the support units you've mentioned? Yes, absolutely. I can do that. The issue is that it's probably better for me to reach out directly. Sometimes it's let me circle back, because some of this is confidential and some of it's not. So let me circle back and see what I can share on the chat that can be publicly shared. And I'm also happy to share up more bilaterally with those of you who are interested with the specific email addresses. Is there anything else, Jule, on the?
There's a question about the number of countries that have indicated they'll be making submissions, whether that is public, and whether there has been engagement with India specifically, the question asked, but maybe we can speak in general about, yeah, kind of if the names of those 50 states are public or not.
Yeah, so this number came out, I answered the question, but I didn't type it, so I just initially, so I don't know if that came through, but this number was mentioned by the Vanuatu ambassador yesterday at a public briefing. There are some lists that are circulating, but these are confidential. There are some states, for example, like the Bahamas and Fiji and Ecuador and Costa Rica and Colombia that have come out, the Philippines, that have come out publicly and talked about how they plan to engage. But a lot of the states, we're not sure if we can share that information publicly. So I'll have to go back and see which states would be comfortable with sharing that information publicly. And I'm happy to circle back when we follow up.
Thank you so much. There's also, well, we've said to some of the youth campaigners we've worked with, we've always said over time, there's no really harm in reaching out to a state that has already indicated they'd be making a submission, asking for the process to be more transparent or for civil society to be included, young people to be included. So I think there's no harm in reaching out anyways. And I've read a tough question in the chat that I'd like to throw back to our panelists. And this is from Kath. Thank you so much. I'll read the final questions. There's two ongoing cases at the ICJ, both relating to Palestine. And the question is, how do we ensure we protect the integrity of the ICJ, states' obligations under international law, and connect struggles for intergenerational justice and self-determination, which this climate justice advisory opinion seeks to safeguard? Noma, I saw that you were just reconnecting to the audio. You're able to speak. Perfect.
Yeah, not a problem. I think sometimes when you talk about sort of protecting the integrity of the court itself, so basically making sure that the submissions or the applications or the advisory opinions that we call or demand for this court to basically, call out for are genuine. I think that's a tricky question. South Africa as well has come out of, has faced a lot of criticism for its reason for bringing that specific matter, altruistic or not. Obviously, the issue that's going on in Palestine is deplorable, but the reasons why it specifically took that matter to court have been criticized by some people. And I think the idea here is it doesn't matter why you're taking specific matters to court. As long as there's a specific injustice, as long as there's a specific wrong that needs to be righted, that's what the court should focus on the legal aspects of those things. And its role is not really to contemplate the reasons why a specific state is bringing specific issues to that specific platform. I think if we get into that sort of line of inquiry, we lose the plot altogether. Yeah.
Thank you.
I think I saw a question about sort of judges and sensitizing them or training. I seem to have lost it because I locked off an answer. I don't know if you want to maybe read out that question to me.
Apologies, had to find it again as well. The person is from Natural Justice Nigeria, and they agree with your inclusion of the courts in the climate justice movement, but however emphasizes the need to also train judges on environmental and climate change litigation, because not all of the African states have judges grounded in these areas. The question reads, or the statement.
Yeah, that's very true. So not so much a question about the ICJ. Generally, it's more about sort of the capacity that some of our jurisdictional domestic courts have to be able to deal with these nuanced cases that deal with climate aspects. Often you're thrown figures about GHG emissions and scientific reports about marine life and whatnot, and it can be confusing a little bit. But I think some jurisdictions have basically set up what are called environmental tribunals or forums. So these are specialized courts that deal more specifically with environmental cases, with judges that are well trained on those specific issues. I know there's some civil society organizations in Zimbabwe that are basically working on the adoption of that sort of approach and the creation and establishment of those sort of forums. I don't really think that's necessary per se. I think any courts, whether specialized or not, have the capacity to be able to deal with environmental justice cases. I think the issue is in training, is in sensitizing, is in making sure that our judicial officers have as much information as possible about the climate crisis, but also about the public interest factors that have an impact on the protection of our indigenous peoples, on the protection of our environment. And constitutional principles generally speak to human rights issues, and human rights issues speak to environmental issues. So I don't think there's a need to pool resources necessarily to set up these courts, but different strokes for different folks, different things work for different jurisdictions. So yeah, I hope that answers that question. Or comment.
Yeah. Yeah, thank you very much. No, I think it's very interesting that people are thinking of the next step, what happens, what's important for when it has come out. And before, I think I'd ask both panelists to share your final call to action with our audience. There's a final question in the Q&A box, and either of you or both of you feel free to respond. The question is about distinguishing between the formal submissions by international organizations versus written statements by NGOs. How are international organizations defined? And Joie, you mentioned earlier that the line isn't exactly clear, and that's, I think, what the question is asking. When is an NGO an international organization? And what's kind of the difference between the submission that they might be making?
I think that's exactly right. It's not clear. I think Article 66 basically provides two criteria for participation of non-state actors formally in the process. And one is that they must be an international organization and that the actor must be able to furnish information relevant to the AO proceedings. It's also been difficult because when the court actually grants leave to an international organization, it does not lay out its reasoning why it basically granted leave to X organization but rejected leave the application to intervene from another organization. If you go to the court's website, you'll see like there are these short kind of statements about the court granting leave, but there isn't reasoning included, so it is difficult. It was interesting that the court granted leave to IUCN because IUCN is not purely intergovernmental, which is usually how usually the kind of organizations that get granted leave. So there is a possible opening there. I encourage people, if your organization is spread out across different countries and you can make a valid case that it is an international organization, you can try. I think that question came up on the leave, like it's 1 month before. There is a lot that the court is dealing with. I think even state alliances have not gotten a response for a while, so the court is quite overwhelmed. So I don't want to give false hope that there's huge likelihood of this being accepted, but it's always good to try and to push the court on procedural matters. So I'll stop here.
Thank you very much. And before we have to end this morning's or this afternoon session, I'd give both of you again, and starting with you, Noma, giving you a challenge. If you can kind of put out a call to action, a summary, or a response to something that Joie said this morning within 60 seconds, that'd be very much appreciated. And thanks again for joining us this morning.
Not a problem. Thank you for having me. I think if I were to summarize, I would talk about the mantle again, holding that torch in that mantle and lighting other torches and other mantles and galvanizing as much support as we can to hold our states accountable, to ensure that we emphasize the duty and the responsibility to participate in this crucial process. It is not as voluntary as they think it is. They owe their citizens, their indigenous communities, a debt to participate and to represent them, so that they don't suffer the consequences of disaster when the climate crisis comes to fruition. So that would be my call.
Thank you very much. Joie, same challenge for you.
Yes, just to keep it very short, essentially that the AO, it's not about just what is happening at the courtroom. It is very much about how we're able to take the arguments that are being made, the needs that must be met in the face of climate devastation, and making a discourse out of it, building the narrative, using it to mobilize and build power and create the foundational basis for campaigns. And that is why it is not just lawyers that will make this process successful. It is all of us as a broader movement for climate justice and human rights that will make this kind of a process really shine through in terms of being able to deliver climate justice. So I think if I had to say it very shortly, Jule, I'll say just this.
Thank you, both of you, so much. A lot of what you said this morning is very poetic. So I was taking notes, and I feel like I've heard everything about the AO over the years, but there's still so much I've learned. So thank you very much for spending the last hour with us. And unfortunately, we have to come to an end, but there's still a few questions in the chat. So if Joy, Noma, if you have a second and you'd like to type some answers, feel free to do that. Otherwise, thanks again to all the co-hosting organizations. There's still some resources in the chat. Feel free to save them. And yeah, we are very happy to share resources and templates afterwards. And a big thank you for joining us, and then an urgent call to action to use the next 4 weeks wisely. And thanks to our audience for asking all these questions. Thank you very much.
Thanks all.
Thanks, everyone.